Thank you for attending the Williams-Mullen COVID-19 Comeback Series. My name is Robby Lawson, and together with my partner, Alyssa Embree, we will be discussing a topic today, which will be landlord and tenant negotiations for existing commercial leases amid the COVID-19 pandemic. This topic will be discussed in three different parts. Part one, responsibility for rent during a forced foreclosure. Who's responsible? Is the tenant responsible? Part two, landlord and tenant workouts for continued operation by the tenant in the premises. And part three, tenant exit strategies once the tenant decides that it can no longer operate. And with that, we'll start with topic one, responsibility for rent. And I'll ask Alyssa, what arguments might a tenant have for not being responsible for rent during this time?
Hi, Robby. Thanks for being here today, everyone. My name is Alyssa Embree, and we're happy to discuss why a tenant would have a claim for non-payment of rent during this time. So force majeure is probably the most commonly referenced clause in someone's lease. And here we would say, as a tenant, they simply cannot pay rent due to circumstances outside the control of the tenant or the landlord. And here during these times, it's out of really the ability of the landlord or the tenant to really be able to predict or have any control over the events. So as a tenant, I would say, there's no way I could have predicted all of this happening. I can't operate my business and I need relief from my rental payments under the lease. And I would claim force majeure.
Alyssa, that's a great point. Some of the leases, however, may not have a force majeure clause. And also some leases may expressly state in the force majeure clause that it doesn't apply to the payment of rent. Are there any other arguments that a tenant may have if a landlord raises these points and pushes back on the force majeure clause argument?
That's a great point, Robby. And force majeure generally could or couldn't include rent, as you mentioned. So perhaps you would say it was impossible or illegal to perform as the tenant. Obviously, there were governmental orders issued on a state level that made it very difficult, if not impossible, for certain types of businesses to operate. Some of them, in fact, are still completely prohibited. You're not allowed to be open, and you can't have any other way of operating your business or receiving revenue. So as a result, you would say it would be impossible or illegal to perform. And if it's impossible or illegal to perform, as a tenant, you would argue you shouldn't have to pay rent. But Robby, as we see, both the landlord and the tenant would have good arguments as to whether or not a tenant would be responsible for rent during a forced closure as a result of force majeure, impossibility, or impracticability. But rather than trying to litigate that in court, mainly because there's still not a good amount of case law about these issues at all, never mind during COVID-19, let's talk about other ways we could potentially settle it or work it out together without having to go to court.
I like that idea, Alyssa. That's a perfect transition to topic two, landlord-tenant workouts for tenants that want to continue to operate. What items might a tenant ask for a landlord as some sort of relief during these times so that the tenant could continue to operate?
Well, Robby, we would ask for things like a rental deferment or a rental abatement, which are different types of receiving relief from rent. A rent abatement would be not paying any rent at all during a certain amount of time, and a rent deferment would be not paying rent during a certain period of time, but then catching up on that back rent in the future. Another way to have relief would be to ask for non-payment of base rent, but to just pay CAM or other costs that would just be more minimal right now during a certain specific part of time. Another option would be to broaden the permitted use. We've seen in a lot of instances where tenants have been able to expand their use to include things like having alcoholic beverages or having outdoor seating areas. And here in Virginia, that's certainly been something that everyone has really embraced. But we would also ask that our landlord would realize that we need to have the ability to do that, perhaps in a shopping center if you're a restaurant. So allowing me to have the ability to operate beyond what the permitted use is currently in my lease so that there's a chance I may be able to get enough revenue to pay my rent.
Those are some great ideas, Alyssa. What I would respond back to my landlord is saying, well, before you start looking or talking about abated and deferred rent, maybe review your loan documents and talk to your lender to see if that's even permitted. You wouldn't want to defer or abate rent if you're now in immediate default of your loan documents. And as for the expansion of permitted use, that's great. and that's free to the landlord. The thing that the landlord needs to be careful about there would be looking at other tenants' leases to make sure there aren't any exclusivity clauses in those leases, to review the restrictive covenants to make sure there aren't any other things that are permitted or not permitted in the shopping center or office complex or whoever the tenant is there. And responding back to your rent reduction, what I would probably recommend to a landlord is asking the tenant for an application, to fill out an application, asking them for a business plan, their financials, their sales reports, to make sure the tenant really can't afford to pay rent during that time. And if we're talking about a rent abatement or a rent deferment, my recommendation would be, if you agree to that, maybe extend the lease out the months that you would give that deferment or the abatement so that the landlord also gets something there. A landlord may also want to add a personal guarantee to add some additional assurances that the tenant, wants to be in here as well. And finally, the tenant may, if they default later, I would recommend that the landlord say that any abated or deferred rent would be immediately due and payable. Would those types of items be helpful to your tenant?
Robby, that would be great. And as a tenant, those would definitely be items that I would want to consider and discuss with the landlord. But as we've seen before, this pandemic has gone on for quite some time, and we really don't know how long these different restrictions are going to be for each of the individual states and types of businesses. Let's assume that even if the landlord and tenant work something out now, still several months down the road, it becomes difficult or impossible for the tenant to pay their rent again, despite that there's been a workout on the rent or maybe some change to the operating hours or to the rent structure. And instead, the tenant finds themselves unable to pay. Then what do we do?
Well, that brings us to our third topic, tenant exit strategies, if the tenant cannot continue to pay rent. I think I really see three different exit strategies. The first one being some sort of mutual agreement between the landlord and the tenant that allows the tenant to vacate. The second exit strategy being maybe assigning the lease or subletting the lease premises to a third party. And the third one would be the tenant walking away, handing in the keys and saying, I'm done.
Robby, that's right.
And can you explain these strategies?
Right, yeah, and termination negotiations that I've seen can center around some sort of termination payment, often a combination of unamortized brokerage fees, perhaps a reimbursement of any tenant improvement costs or anything that hadn't been spent yet, and then also maybe a monthly lease payment as well.
And I see the termination fees anywhere between 3 months and 2 years of rent. So it really is another discussion that opens up. But these strategies can be very helpful and might be a win-win for the landlord and the tenant. The other thing that I've seen is where tenants may ask the landlord if they'd be willing to give them a reduced rent, but the landlord may be willing to terminate the lease early. So the landlord comes back and gives them 50% base rent, but upon 30 or 60 days notice, that landlord can terminate the lease early if they found a replacement tenant. So that's another good idea as well.
And speaking of replacement tenants, Robby, also assigning and subletting would also be ways to get a tenant out of a lease, but still have a space that's occupied by someone. In a subletting context or in an assignment context, you often see that the landlord has the right to consent to whoever is coming into the space and whoever is the successor to the lease. Working out an option with the landlord to perhaps have another party come in and take over would be a way to get the tenant off the hook, but also to have the landlord still have that space completely occupied. Another option would be for the tenant just to hand in the keys and to walk away. But it's very important to remember that oftentimes tenants have guarantors that have personal liability as a result of anything that happens during the tenancy. So if the tenant just hands in the keys, they may be risking some serious liability with the guarantor, and the landlord may have a recourse against that guarantor. And as we're seeing right now during all of these times, we're really having landlords and tenants come together and work something out. We strongly suggest that rather just handing in the keys and walking away or just saying, I can't pay rent and throwing my hands up, that you work together as a team with the landlord and the tenant. Everyone is in this together right now, and we want to make sure that there can be a mutual agreement between the parties that may be much more beneficial than just walking away. And with that, we'd like to thank you very much for joining us today. We encourage you to visit williamsmullen.com for any of our other additional resources, and to please reach out to Robby or I if you have any questions or if we can help you in any way. Thank you for attending, and stay safe.